All right, thank you. Well, I know it's the afternoon session and we are kind of short on crowd here, but that's fine. But it's an interesting topic that we have at our hands today, right? And we all talk about it, we all know about it, but the real dynamics as to how a corporate or an individual really gets affected is something that we really haven't been able to articulate well in the industry. So the Prevention of Corruption Act, which kind of came in 1988, and further got its amendment done in June 2018. June 2018 to where we are today, there is a lot of deliberation as to what people would like to do, how would it really help the overall industry, what are the corporates liable for, what are individuals liable for, and what is the government doing about it. So that's what we have. So we have eminent panels of lawyers and industry veterans today with us who will kind of walk us through what they would like to do. So what we're trying to do today is to cover basically in short the entire life cycle. We'll kind of go through the entire evolution, the act itself, what are the amendments, and what are the implementation challenges. To actually, that's how we're trying to run it. And Robert will probably come in from his next session later to kind of walk us through what the international aspects of those laws are. So to start off with, what we've decided to do is that we'll kind of talk you through these specific points for 5 to 7 minutes, and then we'll ask questions and more practical questions as to what are the challenges that we've been facing in today's industry. So to start off with, I would like to kind of ask Atul if he can kind of walk us through the evolution of the PCA, what we call it as the Prevention and the Corruptions Act, and we can take it from there.
Thank you. It is just like as board meeting. I am a company secretary, so it's just like as board meeting. But anyway, we can talk. See, Prevention of Corruption Act was enacted in 88. So, question is that whether the corruption was there before that. And to answer that, corruption is there from the ages. If we go through the history, Chanakya mentioned that in Arthashastra that government departments heads should be on a vigil. What they do, where they go, how they work, what is their performance, whom they meet. So that is mentioned in that time also the corruption was there. Bringing into relevancy, 1860 IPC covered the corruption by 160 section number 161 to 165 before the Prevention of Corruption Act was enacted. So, and Prevention of Corruption Act was enacted to consolidate the provisions, particularly it is related to the public servants, government departments. As you know, the data, even OECD or maybe internationally also, the main focus is on the government department corruption. You take any kind of act, international act, or maybe our OECD also. So that's how the Prevention of Corruption Act came in the picture actually in 1988 to consolidate the provisions, and naturally from the IPC the sections were taken out to cover it in the Prevention of Corruption Act. You want me to cover the particular? Yeah, sure. Yeah. So in Prevention of Corruption Act was passed actually, but as you know, we take the clue from international, but we do it in Indian way. So there was disconnects. Prevention of Corruption Act was original in 1988. Focus on the bribe taking and not bribe giving. So supplier of bribe was not covered actually. He was given a protection under section 24. So bribe giving was a crime, but bribe taking was a crime, but not the bribe giving. It was not. Of course, you can cover it under Corruption Act, the IPC Act, but not under Prevention of Corruption Act, because there was the immunity was given under section 24 that he gives declaration and he will be out of it. This act came in 1988, but cases started from 2000 onwards. There is no old case. Act, as mentioned, covers public servant main, and now public servant definition was so vast that it covers judges also, arbitrator also. So, but it was extended to such an extent in one famous case where Global Trust Bank fraud was there. The CMD of bank was considered as a public servant. Bombay High Court said no, but Supreme Court said no. Yes, he is a public servant in the Act of Prevention of Corruption Act. So this is the background of the particularly Prevention of Corruption Act 1988. With this, I will.
Yeah. Sure. So that's the act, and as I was talking about that, we on 26th July, rather 2018, the amendments kind of came into place. The amendments were primarily categorized around 8 specific aspects, which Sir was talking about. So to kind of take you through those acts, amendments, I'll ask Kunal to kind of brief that.
So basically Prevention of Corruption Amendment Act 2018 was notified on 26 July 2018. It is largely based on the United Nations Corruption Convention Against Corruption, which was ratified by India in 2011. Just to take it forward from what Atulji had said, the first scam that India saw post-partition was in 1947 itself, where instead of some 500 military jeeps, only 155 jeeps were actually supplied. And that scam actually went into some kind of a case, not under PC Act because it didn't exist. At that time, it was really under IPC where you could invoke the cheating provisions of IPC and Section 161, etc. provisions of IPC. Hence, the PC Act came and it focused mainly on the bribe taker aspect. And there was a growing need because the bribe giver was always charged with sections under the Indian Penal Code, where the PC Act read with Section 420 IPC and 120B, which is the criminal conspiracy, they were charged with. And most of the times we saw that the bribe giver would just walk away freely and he wouldn't be convicted because of lack in proving Section 420 ingredients. Hence, the requirement for this amendment came, though the requirement should have arisen much earlier, but only in 2018 that we saw this amendment. So I'm just going to take you through certain large points which were basically added in the Amendment Act. First and foremost was that the bribe giver was also considered as the accused person under Section 8, which was amended along with the bribe taker. And hence, it was both now bribe taker and bribe giver who will be charged with Prevention of Corruption Act offences. Second biggest structural change which the amendment does is that the time limit, which was never there in the PC Act, has now been brought down to 2 years, which means that you will have to, the judges or the special courts which have been appointed will have to complete the trial within 2 years, which is extendable by 6 months at a time to a maximum of 4 years. So gone are those days when we used to see for 25 years the cases are going on, and when we reach the trial stage, we find that, oh, most of the witnesses are already dead. So time limit is the second aspect which helps the PC Act. Third, and another important structural change, is in relation to a person who is taking a bribe to influence a public servant. That is another area where under PC Act which has been added. Fourthly, and another structural change, and why I call it structural change is because earlier to make companies as an accused, it was always a problem because you had to bring it through the route of the IPC. Now the commercial organizations themselves can be charged with the Prevention of Corruption Act offences. So commercial organizations like companies, partnerships, your LLPs, or any other entity which is doing business in India. It even includes now the foreign entities which are doing business in India. So all that gamut has come out through the Amendment Act. Thereafter, the concept of person associated with these commercial organizations has been added, which means a person who is associated with these commercial organizations can also be charged with the offences under the Prevention of Corruption Act. if you will be aware, the commercial organization itself cannot be sent to jail. It is the persons behind that commercial organization who must be sent to jail. But a fine can be imposed. So there is a provision now of both fine and imprisonment. 3 to 7 years of imprisonment and a fine can be imposed. Thereafter, the concept of a person in charge has been brought in, and two very important defenses, or I would say leniency provisions, have been created in this Prevention of Corruption Act, which we've never seen earlier. One is that the commercial organization, like a company, can just take a defense that, listen, I took all the possible measures and adequate measures, procedures as prescribed, so I shouldn't be held liable. That is number one. Number two, a person can actually prove that he was compelled to take a bribe, and he has to then report it within a period of 7 days. So these are the two very important defenses which are available to the accused people accused of corruption activities. Then there are provisions relating to attachment and forfeiture of property in respect of those people who indulge in these activities. So these are really the changes which have come about. These are surely welcome changes, and as we proceed, we'll see whether these changes which have come about have actually been implemented on ground, and what are the challenges we are likely to face with these kind of changes.
Sure. I think the amendment also gave the option to let the people, rather the government employees, to give off the radar. So you want to throw light on that?
No, I just wanted to add actually Section 9 particularly, you mentioned about the commercial organization. The Act has come in the picture, amendment has come in the picture, but now in Section 9 he says the two defenses which we get, particularly commercial organization, such guideline as may be prescribed, the guideline will take its own time. So that is missing. So we have to demonstrate which guideline we should use. So maybe that is a lacuna. We'll cover the lacuna later, but I wanted to make that point. And yes, within 7 days, he said 7 days is a limit to particularly
report.
To report.
Yeah. No. I was just saying that with this act also, if you have to kind of go and prove that a government employee took an thing, so they have a leeway to. You can't really go and start a case against a person in power immediately. You have to take special approval to kind of go to that.
Has always been a concept of taking sanction from the appropriate government. So for example, it's a state government employee, then it has to be the state government which has to give the sanction. If it's a central government employee, then it's the central government which gives the sanction. That concept still exists in the amendment also. And interestingly, now the definition of public servant through various judicial pronouncement has found favor in the Amendment Act, where they include people like bankers, arbitrators appointed by public authority. So certain people acting in private nature but conducting public duties have been added as public servants as well.
So we all have heard, right, that we have the UKBA and the US FCPA, which have been in existence for a long time. Now, if you take both these two acts and you add the Amendment Act also, which has been passed in India, how do you really, correlate both of them? Because that's where the practical challenge for us is. Because a lot of corporates, global multinationals who are working in India are aligned to the UKBA or the US FCPA. So how would you, see this coming together in the short period of time?
Yeah, as I mentioned, the first lacuna that the defense, they are not guidelines prescribed, so it will come. It takes own time unless industry makes a representation for that. But yes, differences between the FCPA, UK bribery, and this complete prevention of POCA is the US FCPA is oldest legislation 1977, but US people are practical, so they excluded facilitation payments. Facilitation payment means small payments which are done and which can waste your time in the processing of the papers or files. So they made a differentiation between facilitation payment and a bribe. And particularly UK bribery is a stricter act. UK bribery makes private organization also covers private organizations, whereas we are only covering the public organizations. And as you mentioned, particularly is the taking of permission. Actually, the act becomes slightly unpractical, unimplementable, because taking the permission, they have taken 3 months. They have given 3 months time to reply, plus 1 month extension also is given. So it seems that by that time, the people can do whatever they want to do, as we do in India. So that's the difference actually. But it has come out now more or less on the international perspective. The reason is that they are now covered supply side, which was a major lacuna in the Prevention of Corruption Act.
Yeah, so just adding from what Atulji said, UK FCPA basically is governed by two principles. One is the domestic concern principle, and the second is the boardroom to supply room concept. Domestic concern principle means that a company which is in the USA and it is doing business anywhere in the world is the one which will get affected by any act. The second boardroom to supply room concept is that each and every person from boardroom to supply room is kind of sensitized as far as FCPA is concerned. There are detailed guidelines by the Department of Justice and the Securities Exchange Commission, who are to conduct, as we call it, an audit on a routinely basis. So those are things which are not available as far as the Prevention of Corruption Act in India is concerned. But I guess we are moving with the amendment. We are yet to see how the amendment takes effect on ground, and I'm sure it will work well if the agencies who are investigating these offences are up to mark with what is happening around the world.
Right. So as I was saying earlier, we have Robert back with us now. So, but right in time though, we were just talking about the UKBA and the US FCPA. So from your international experience and you looking at it from an outside in view, and the recent amendments that have happened to the PCA here in India, what is your outlook to all of this?
Thank you. My apologies for being delayed in another session. I think we have to understand that the dynamic of international cooperation, if it's already been touched upon, has changed. I know enough investigators who have badges and guns who no longer worry, unless they have to, about mutual legal assistance. They get on their WhatsApp group, they get on their email, they read what the media report, and they investigate. And they start making inquiries between agencies. And increasingly, although the US used to be an outlier and would effectively do whatever it wanted to do for its benefit if it considered US laws had been breached, some of the more recent DPAs and investigations have shown that even now the US is starting to recognise that countries such as, be it Denmark, Sweden, Brazil in particular, and the UK with Rolls-Royce, should be given the credit of the major running in these investigations, and that therefore there's increasing cooperation, increasing exposure for companies that operate globally, and that even though you don't necessarily have a domestic law that, for example, prohibits foreign bribery, you will almost inevitably have local laws which mean directors and individuals can be liable for conduct, for example, here in India. And if you're an individual who has been overseas in the US or the UK and you've engaged in conduct, or you are an agent of an overseas person, you may suddenly become subject to overseas laws. So I think what we're seeing increasingly, and I'm seeing it across Asia, from Australia up to China and from China across to India and into the Middle East, is that governments are now realising that corruption, fraud, money laundering are serious issues. We've known that for a long time, but frankly, many countries in the Asia-Pacific region have largely ignored it. And that's why the Americans got so upset, and that's why the Americans started throwing their weight around and starting to penalise foreign companies and foreign individuals. So I think we have to understand that, and therefore business has to be so much more proactive in dealing with it, because countries like Australia are starting to follow the model of the UK and create strict liability laws for companies. That is the Section 7 Bribery Act offence. That is, if you as a company fail to have adequate procedures in place and you are subject to UK law, then you are liable absolutely for whatever happens down your supply chain, potentially, if your associate or the person associated with you has engaged in offending conduct. So that opens up the corporate veil. Common law traditionally has protected the corporate veil. Each company is different, each company is discrete. People involved in one company are not necessarily involved in another company, and what company B does in Botswana or Tanzania or Mauritius has got nothing to do with me in Australia or you in Mumbai. Now, under these strict liability laws, that's irrelevant. The fact is they can follow the line up, and if there are benefits or gains by the parent in Mumbai or Sydney, you are responsible for what happened in Mozambique or Indonesia. So these types of laws are now coming in because regulators have found it too difficult to make companies and groups of companies outside America really responsible for their supply chain and their subsidiaries. And that's what I think is one of the most important things that's changing.
Sure, yeah, that's interesting. So we'll kind of shift tracks now that we've kind of given you an entire overview. With the Act, what we've realized that we've seen multiple time limits, right? We've seen time limits of 2 years set, and we get extensions of 6 months each, is what the law says. But looking at the Indian scenario, and I would want two views from the Indian lawyers as well as from an outside view, as to how do you see this panning out? Do you think that the time limits that are set are realistic? Do you think there would be a closure to all these amendments, all these acts, etc.? Or it's just another time limit for the sake of it? So I'll start off with
I
the
think international view would be
better, and then I'll probably ask the Indian view.
Well, the international view is that if you have a serious criminal offence, assume that's what we're talking about, there is no time limit. The only time limit that exists in most common law jurisdictions for criminal offences are essentially minor summary offences, and in many countries they might be 6 months, 12 months, or possibly 2 years at a pinch. Whereas in Australia, the UK, they're unlimited. So it doesn't matter that you have a serious criminal offence, fraud, money laundering, corruption, bribery, that occurs 3 years earlier, 6 years earlier, 10 years earlier. It may well impact upon the penalty that applies, because the penalty may be substantially less, because in many countries those penalties have substantially increased over the last few years to make them bite when regulators prosecute. But in terms of time, in my view, there should be no time limit.
There was another question to it, leading to it, that there's no time limit to go back, which is true. But the trial timeline in India, effective the amendment, has been reduced to 2 years, extending a maximum of up to 4 years and taking a 6-month extension each time. You think this is a good timeline? You think this is a positive step in that direction? Will it be able to resolve in that time, or you think there's more time required to kind of take it to the final closure?
I think that is ambitious. The OECD published a report in October, November 2016, I think. It surveyed every foreign prosecution that had happened over that preceding 15 years, the length of the OECD treaty convention. And they found that the average time, this is the average time, not the real time for each case, but the average time for a bribery prosecution was 7 years. And we now have our Australian Federal Police telling anybody who wants to listen to them, which is not everybody, that in fact don't blame us because it takes so long, because the OECD tells us it takes 7 years to investigate these cases. Now, that, in my view, is lazy. There's a laziness about it because it just means they just do things at their leisure. I, in fact, see some merit in requiring things to be done more quickly. The downside of this is that, well, are people, regulators, investigators, going to be properly resourced? Are they going to have the funds to do it? because these investigations, and having been in them for many years, are often very complicated, involving foreign jurisdictions, foreign players, foreign languages, tracking the money, people who are not necessarily friendly to a country investigating. Even governments of foreign governments don't necessarily want another foreign government investigating their domestic foreign public officials who were alleged to have received or taken bribes from, for example, an Australian company. So if there is a timeline, I think there is some merit in it, but I think it's pretty ambitious.
Yes, I think I would agree on one point with Robert. Yes, it is ambitious. Secondly, I must clarify that this timeline is the trial timeline. It's not the investigation timeline. So investigation is excluded. Trial begins when we file the charge sheet, as we call. That's the document from where we start our trial. Yes, when we say it is ambitious, it is really ambitious because we've seen this in many, many enactments in India where the timelines are given and courts are never able to achieve it. But in this case, especially, the Amendment Act also creates special courts and special judges for the purposes of taking up cases under the Prevention of Corruption Act. And the reason why this timeline is also needed is that many a times, and my experience is many a times when we start doing trial after about, let's say, 14 years, 15 years, we find that most of the witnesses are dead and the accused is happy. I mean, if we are there for the accused people, we are very happy because the witnesses, our main witnesses are not there. So I understand that 4 years may not be achieved in that strict sense, but surely this will bring down the total time that we've been taking for prosecuting these kind of cases. And it will come down to, if not 4 years, 5, 6 years is a good way to look at to start with.
I agree on the timelines is a challenge, but it is good that they mention it because then also there is a pressure on investigating agency as well as the adjudicating agency. Otherwise, there is no pressure. Then it goes on and on, tariq pe tariq, that goes on and on.
Can I just add to it? In Australia, we had a Royal Commission, which I mentioned in another session, about in the banking and financial sector, which opened the lid on some seriously systemic criminal conduct, or potentially criminal conduct, I should say, by our largest trading banks, our largest insurers, our largest superannuation companies, and individual officers involved in this. It's been public in Australia for the last year. And as a result of that, the federal government, which is conservative in politics and has long resisted, because of their connections and funding and contributions by banks and finance companies, to really ever investigating them, has had no choice, because of the political pressure and the publicity, to effectively now refund our corporate regulator, which has had its funds cut over many, many years. And more interestingly, because our state courts in Australia are the traditional criminal courts, they're so overworked and underfunded that most criminal proceedings take in Australia a long time. Even though judges try and administer it and try and docket manage cases efficiently, they still are limited in what they can do. Now our federal Australian government is trying to reallocate resources to our federal court and to make sure that courts are set up with experienced criminal law judges, even if it's in cartel environments, in crime, in tax, to basically run jury cases in the federal jurisdiction, which for Australia is quite unusual because they're mostly run in state courts. So to that extent, I think the concept of expedited trial hearings is thoroughly to be commended, because justice delayed is almost always justice denied somewhere.
Yep, that's true. So, we've seen that. So, Kunal, I have one more question for you, and then I'll throw it open to the audience out here. Is that we've seen that, we've got the act, it's got amended, but there are ongoing cases, right, on a continuous basis. How does this change impact those ongoing cases, and what are the, challenges, or if I may say, how does the amendment take care of those challenges?
So as far as the ongoing cases are concerned, according to me, the amendment is going to be prospective in nature, not retrospective. So wherever the offence has been committed and charge sheet has been filed, the trial has begun, the amendment is not going to help that, and they can't take care of this. The real challenges which we face are the achievement of this timeline and the infrastructure. And sharing my own experience, I have in fact last year finished a case where there was a CBI trial. I was appearing for two main accused, and the FIR was filed in 1993 in respect of an offense which happened in 1984. I passed out law in 2003, and I took up the case in 2014. And then came the direction from the High Court that if the case is more than 25 years old, you can't take a date. The trial has to go on day to day. The trial went on day to day and still took 3 years from there to reach the final hearing stage. So 2017 is when we got all the accused acquitted. I won't boast of it because most of the witnesses were dead. So obviously the prosecution had failed in proving the case. So this is what the challenge is for us. The implementation, the investigation is not bad. The problem is that by the time we reach the trial stage, most of the people are gone. So what do we do about it? So this timeline is really going to help, at least telling the judges that you have to comply with 4 years, if not 4 years, 5 years, 6 years, not more than that. And secondly is the infrastructure. We are creating special courts, we are creating special judges who are being given these kind of cases. They don't have to do 50 cases in a day. They just have to take up 1 case a day. And they are finishing these kind of cases. So things are moving. It's not that it's not moving. And with these kind of strict timelines, we are getting there.
Sure. If there are any questions in the audience, or yeah, please.
Hi. Just one question on the implication of companies which are governed by FCPA. Now with the amendment in Prevention of Corruption Act, so if a company has been fined under the SEC, do they have to undergo one or more litigation for paying bribes in India as well? Because under the new act, the payer of the bribe is also to be prosecuted. So is it a double jeopardy for the US operating companies in India?
You mean to say, are they going to be prosecuted in the US separately and in India separately?
US anyways it happens, but we never hear of cases where...
So if it's an offense relating to India, they will be. And US will take care of its own law.
Yeah, so for companies which
That's not double jeopardy. That's offense being taking place in 2 different countries.
Yeah. Because currently what happens is you hear all the sanctions and fines which are levied by the SEC, but you don't get the other side of it. People paying bribes in India. There's no prosecution in India which happens on these companies. So with the amendment in Prevention of Corruption Act, is that a new avenue which will open up?
See, amendment has happened in July 88, right? Sorry, July 2018, right? So it will be effective from July 2018. Now to answer your query, whether the companies which are FCPA applicable and which has particularly undergone the action and in US you pay penalty and you are out. Here there is a 7 years imprisonment, 3 to 7 years imprisonment. So after 2018 July, if there is a crime, definitely there will be, and even after July 2018, the crime is there, definitely it will be applicable in India also. There is no double jeopardy. Then the question is that whether the company is incorporated in India. So they will have to abide by the laws of India. So if it is a US company, then again the question is different. Fine?
No, so just adding here, so even if it's a foreign entity doing business in India, it will be covered here. So it's not necessarily that it has to be incorporated in India. So by virtue of you doing business in India, you are liable for all the acts that you do in India.
One actually lacuna which I have not covered, which I want to cover since we are talking about FCPA. This law doesn't cover Indian company giving bribe outside India.
Yeah, but it automatically gets covered.
That doesn't mean that your company goes and does that.
All right. So as I said that this is a topic that we can talk for us together because it is interesting and it's still evolving much more. I believe I've been told that I'm running out of time. So is there any final question, or I think we can close? All right, perfect. So just like to kind of end up that there is a lot that has happened in India. There are some procedures and implementation challenges that we will face where we don't have a roadmap yet after the law has been passed. But what we're trying to get there, and I think that's a good positive step from all sides of it. And I'd like to thank everybody on the panel for sharing their insights and pleasure. So if there's any questions, they're there down, so you can please ask them there. Thank you so much. Thank